what is your prayer?
My prayer, my Lord, is that the application be dismissed, my Lord, and the orders granted, and that in be confirmed.
I'll take it for you when I'm ready.
My Lord, just to start quickly from the bottom, the decision of Shah versus Mbogo needs to be read together with the celebrated decision of Express Kenya versus Manju Patel. And in that decision, the Court of Appeal at the apex court of this country at the time,
Shah versus Mbogo.
read together with Express Kenya versus Manju Patel.
And understood.
Read and understood together with Express Kenya.
With
Express Kenya versus Manju Patel.
Manu or Manju?
Manju. M-A-N-J-U.
Yes.
Where it was held that where it is...
Citation.
I beg your pardon?
Give me citation.
I don't have the citation. I know the decision because I have relied on it before, but I didn't know I was going to use it because I had it 2 minutes ago.
So you're asking me to go and look for the citation?
I can supply it to your court clerk.
No, it's okay. I'll get it.
Where it is held, my Lord, that where it is established that service was not effected.
So that, where?
It is established that service was not effected.
That service?
Then the orders made by the court should be set aside ex debito justitia as a matter of right, as a debt to justice.
Should be set aside.
Yes, ex debito justitia.
That's what Omondi says. Is it Omondi? The other one is saying Patrick.
Yes, that is what it says. My Lord, the reference to Rule 14 of the Mutunga Rules
As a matter of right.
as a matter of right. My Lord, the reference to Rule 14 by learned counsel for the petitioners is an afterthought. The evidence of service, and I will come,
Rule 14
of the Mutunga Rules, is an afterthought. Because the evidence of service is the affidavit of service of Noel Oduori of the sworn on the 13th of this month. And in that affidavit of service, the law or the procedure directing service, according to the deponent, is Order 5, Rule 22, B and C.
Order 5.
Rule 22, B and C. And well, there is the submission about, or the question that learned counsel posed to court. How else are Kenyans expected to reach certain high offices? Inferior quality of service that the petitioners have answered. It cannot be then Article 50, and it is for the petitioners then to ensure that the quality of service that they effect complies with Article 50. Everybody is entitled to the protection under Article 50, and I had stated in my submissions in chief that service is the gateway to Article 50. If this quality of service is allowed, what will happen next is that learned counsel will wait for the Inspector General's car to drive by, and he will fling pleadings at it and come to court and ask, but how else did you expect me to get to the Inspector General? My Lord, the responsibility to effect service is on the officer authorized by the court to effect service. That responsibility is not co-shared between the officer serving If he is not an advocate, the advocate instructing that process server, or the client that is instructing the advocate in the matter. That responsibility is on the person who served process. I say so, my lord, because there are explanations in the replying affidavit to the application that is before you this afternoon that seek to make clarifications about the affidavit of service. When your lordship considered this matter on the 13th, what was before you was the affidavit of service. That is what evidences service, nothing else. My lord, paragraphs 12, 14, 15, 16 of the replying affidavit are not contained in the affidavit of service. And because I have submitted that that responsibility is not co-shared, it is important for me to submit that those are not averments by the process server. Whoever is deponing to this affidavit merely instructed the process server to serve. They did not effect service.
Mr. Yamodi, on one hand, you notice I'm looking for something, so you don't expect me to record you.
Most obliged, my lord.
I'm looking for the affidavit of service.
I had asked earlier.
On which day you're looking for the date?
My lord, let me tell you where the affidavit of service is. My lord, it is on page 29 of the notice of motion. My lord, that is the proof of service. And really nothing else can be the proof of service. Any explanations rendered after the fact are after the fact attempts to improve the poor quality of service that is not in compliance with the law. Well, there was a very innovative submission by my learned colleague that the authorities that were cited are distinguishable because they do not relate to service on public officers or holders of constitutional offices. Again, I repeat what I have said, and I think I'm saying it now for the third time. Service is the gateway to Article 50. And for that innovative submission to hold water, then Learned Counsel was obliged to put before your lordship that constitutional office or holders or high office holders are then not entitled to the protection under Article 50. Because what he is suggesting is an inferior quality of service. There was the submission that contacts that were used to allegedly serve the first and second respondents are publicly available. It was important, and this is why I wish to cross-examine the deponent of the affidavit, that averment should have been made in the affidavit in support or in the affidavit of service. The affidavit of service does not say where those email addresses for. There is an attempt to explain where they are from in the replying affidavit, and I have stated that service is an issue to be confirmed and evidenced by the process server. My Lord, circumstances do not give rise to jurisdiction. Jurisdiction of this court emanates only from the Constitution and the law. There have been submissions on behalf of by learned counsel for the petitioner to suggest that the circumstances of this matter then justify the abbreviation of certain hallowed provisions of our Constitution, such as the right to a fair hearing. My Lord, there was a decision there was reference to a decision. I believe it is Andrew Ndaba. I only have the paragraph here on the screen that my learned colleague has shared with me, and I wish to say that decision is applicable for the following reason, and it has been misread by my learned colleague. The decision quotes the case of Union Insurance Company of Kenya versus Ramzan Abdul Danji, and it is civil appeal number 179 of 1998 and reported. And this is the passage from the Court of Appeal. The law is not that a party must be heard in every litigation. The law is that parties must be given a reasonable opportunity of being heard. And once the opportunity is given and it is not utilized, then the only point on which the party not utilizing the opportunity can be heard is why he did not utilize it. That is our point exactly. My clients were entitled to an opportunity to be heard prior to the direction that they come to court. The matter does not commence when they come to court. The matter commences when the notice of motion is filed.
Are you suggesting by any chance that we cannot, at the start of any matter, issue some order? Is that what you're suggesting?
My Lord, parties are heard before summons are issued.
Is that what you're suggesting? Because as far as I know, the law is when you move, the court has discretion to issue order that it considers appropriate. So is it your case that in all cases you should not issue any orders until you hear the party?
Lord,
is that what you're saying? Because it seems like that's what you're supposed to suggest.
My Lord, there are two orders that you have issued. There are two orders that you have issued.
No, it's not about the orders that are issued. You said the argument was circumstances do not give rise to restriction.
My Lord, I want to answer your question by reference to this matter.
Go ahead, I'm listening.
In this matter, you have issued a habeas corpus,
Correct.
which has concluded the notice of motion.
Yes.
You have attend. I am saying that in respect of before the habeas corpus is issued, they are entitled to be heard. And before you direct that they attend, they are entitled to be heard either directly or by counsel.
The law says
Article 50. The right to be heard. You know the case.
Corpus, so that now, that's the argument. Let me record it. We submit that
before orders are issued
habeas corpus
and attendance.
And attendance.
Yes.
Are issued. A party is entitled to
be heard. My Lord, I say so for the following reason. And again, it is a matter that is glaring in this issue. And
remember, I gave you 5 and in your first 5, you collect your thoughts.
Let me collect my thoughts. My Lord, that issue is important in this issue because
everything is important.
It is a verb.
You are responding.
Yes. It is a verb in this matter. And it is a submission that was repeated by counsel that the allegation is that the petitioners are missing.
Correct.
Isn't it? There is no allegation that those petitioners are in the custody of the National Police Service. But your Lordship has then gone on and issued orders to the National Police Service to produce them. And the point I make is that it is important before your Lordship makes an order to produce, to hear the response of all the respondents. Because one of the possible responses to the people are not in police custody. That
is from the bank.
I'm saying that one of the possible responses.
No. We're not talking about the Security Council. Let's say this is a response. So
No, my lord. I'm not saying that that is the response.
So I will say it.
I'm not saying that that is the response. I'm saying that my clients are entitled to a response.
We are not recording possibilities.
Then perhaps, my lord, what I then wish to kindly request your lordship to respond.
Let me record what you are saying.
What I'm saying.
The possible. So one of the possible
responses upon being heard is that the petitioners are not in the custody of the National Police Service. But my lord, having ordered that they be produced by the respondents.
It's not all the petitioners. Is corrected. Second to fourth.
I stand corrected, my lord. So the Law Society is a body corporate.
That's the submission.
And I am a member of the society.
Yes. The second to fourth petitioner.
Because the fifth petitioner is no longer a party. Are not in the custody. And my lord, it is then prejudicial for the petitioners or for the respondents to proceed in a terrain where the substantive order to produce has been made. It is prejudicial for the respondents to proceed in abuse has been made, the first and second respondents. And my lord, because what the matter then becomes is not to produce them, but where are they? That is the effect that ex parte order. And my lord, for those reasons, it is then imperative that the ex parte order made is set aside. The interpretation of Article 22 and 23 in Peter Muya again does not then give the court the ability to abbreviate the proceedings in the manner in which the petitioner has invited it to do. And I beseech you, my lord, to allow the notice of motion that is before you this afternoon in terms of prayers